Our next case this morning is Pitt versus Quanta Building Group LLC. Each party will have 15 minutes to argue. You may reserve up to 5 minutes for rebuttal. How long would you like to reserve, sir?
I'd like to reserve 5 minutes.
All right, very good. I will be keeping track of that time. I'll try to let you know about a minute left if you get to that point that you're running out of your initial time.
Thank you, Your Honor.
The arguments are being recorded. When you present your arguments, please make sure you stand behind the podium, introduce yourself, and please speak in a voice that we can pick you up on the recording.
And let me know if my voice trails off.
Thank you. We will do that. Thank you.
All right, thank you.
You should not use the name of children, minors, or victims. I don't know if that really applies in this particular case, but if you were to be doing that, please refer to them by a title or by initials if you would. We read your briefs and are ready to proceed whenever you want.
All right, thank you, Your Honor. Good morning, Your Honors. My name is Robert Belovich, and I'm here on behalf of the J.C. Jones Corporation. I'm here to ask you to reverse the judgment of the trial court that entered the judgment against J.C. Jones Corporation. This dispute arose out of a project where one Dean Mueller, owner of Cupco LLC, planned for construction of a 35,000 square foot car storage building on property in Avon, Ohio. Cupco engaged a general contractor to construct the building. The structure of this building is a kind known as a pre-engineered metal building, or PEMB. The general contractor, Fortney and Wygant, in turn subcontracted for the PEMB with my client. Construction was originally planned to begin in 2017, but a site issue prevented the start until the spring of 2018. Because of that rescheduling, Jones hired a subcontractor to erect and enclose the PEMB. That was the defendant Quanta Building Systems. Quanta, in turn, hired Pitt pursuant to a subcontract, where Pitt agreed to perform the construction of the PEMB portion of the project. Now, Pitt performed some work, but he did not keep to the schedule that was incorporated into his subcontract. That schedule called for completion by July 9th, 2018. Billing and payments were in this for this project were monthly. Pitt's first 2 payment requests were fulfilled. His third payment request was for work performed in July. It was dated July 20th. However, at that point, the PEMB part of the project was not finished. There was still work to perform, and it was behind schedule. On August 2nd, Quanta sent Pitt a letter giving notice that Quanta found him in default for failing to adhere to the project schedule. And on August 6th, Quanta sent Pitt a letter giving notice of termination of Pitt's subcontract. Now, between these 2 events, Pitt called Jones' president, Jim Jones, recorded the conversation. And in this conversation, he brought a claim based on for promissory estoppel. Now, there is no challenge in this appeal to the trial courts having awarded Pitt judgment for breach of contract, even though the amount determined by the trial court exceeded Pitt's claim, and Pitt admittedly did not keep to the schedule in his subcontract, qualifying as a breach of contract. However, Quanta, after filing an answer and counterclaim, had its counsel withdraw from appearing in this case and made no further appearance. When there was a trial, Quanta was not here. But in addition to the legal relief that the court granted against Quanta, the court also granted equitable relief against the J.C. Jones Corporation. Now, to reach this judgment, the court concluded that the statute of frauds and its requirement for a writing to enforce a promise to answer for the debt of another need not be enforced. The trial judge reached his conclusion by finding that these statements made during the course of a conversation in the evening between Jim Jones and Shane Pitt represented a promise to pay. Maybe you need, Mr. Jones, yeah, maybe you need to talk to him, being Quanta's principal. That would be my recommendation. As far as liens, I'll make sure you get paid before there's any liens on the job, so don't do that right away. There's lots of time to do that. But I'll talk to him and make sure you get what's owed to you, if that's how it ends up. But I think I'd give him a call and see what you can straighten out for your long-range future anyway. The trial judge found that that was a promise to, on which a promissory estoppel claim could be based. But to reach that conclusion, the judge had to find that the statute of frauds and its requirement for a writing to enforce the promise need not be enforced. The trial judge reached that conclusion by determining that the common law leading object rule should be extended from situations where a subcontractor or material supplier supplies labor or materials after a conversation to the situation here where Pitt performed no more work after his conversation with Jim Jones, which included Pitt's threat to put up liens. Now, the trial judge reached this conclusion without expressly finding clear and convincing evidence. This case does not warrant any extension of that leading object rule.
Counsel, can you help clarify something for me? So here, did the trial court find in favor of Mr. Pitt on a breach of contract claim or just on the promissory estoppel claim?
In breach of contract against Quanta and in promissory estoppel against Jones.
Okay. So the promissory estoppel doctrine is an exception, right, to the statute of frauds?
It can be, but it need not be. The only way that it is through the leading object rule. And the Wilson Floors case of the Ohio Supreme Court, which is cited in the brief, makes mention of that. But in Wilson Floors, the material supplier had a conversation with the banker who said, even though we're beyond budget, I'm going to finish this project.
But the decision on the contract claim came not based on promissory estoppel. That was against, I mean, that was for Quanta, right?
Correct.
That was not for
Against
your client.
Quanta,
Against
yes.
Quanta, yeah. Okay, thank you.
So in this case, that extension of the leading object rule is not warranted because of mechanics lien law, which requires that whenever an owner records a notice of commencement, that no lien can be obtained by a subcontractor without first filing a notice of furnishing. And there was no notice of furnishing ever filed in this case. So when Mr. Pitt talked about liens with Jones, it was an empty threat. You can have, if you haven't filed a notice of commencement at the beginning of your project, you can file it at some other time. But if you're late in filing and serving that, then the look-back period is only 21 days. It's not the whole measure of your work or whatever you're claiming for.
Counsel, you just indicated a notice of commencement, which is different than a notice of furnishing. So
Yes.
I want to make sure we're all on the same page here, or at least I'm on the same page. At the time that the promise was, the promise was made, did Pitt still have an opportunity to file a notice of furnishing?
Yes.
And then could have contemporaneously therewith filed the lien?
Absolutely. And the look back for that would only be 21 days. But to get around the statutory requirements, the trial court engaged in speculation, as you suggest, to say Pitt could have recorded a notice of furnishing and with it an affidavit for 21 days of work, but did not do so in reliance on Jones' statement.
And you had about a minute of your initial time.
To reach that conclusion, the court overlooked two undisputed facts. The day after the phone call with Jones, Pitt sent Quanta a letter saying, "We'll be filing liens next week." And then 17 days later, Pitt signed an affidavit to obtain a mechanic's lien. The court's judgment did not address either piece of evidence, but this shows clearly that there was no reliance on Jones' statement. And with that, there was no evidence that was clear and convincing to support promissory estoppel. In contrast, Jones had to finish the project. He had to do undisputed work to correct improper work done by Pitt, as detailed in the briefs. And with that, he spent more. A judgment against him in promissory estoppel is asking him to pay twice and to pay for bad work. So it has to be reversed. Thank you.
No problem at all. You have slightly less than 5 minutes of rebuttal time, but just about 5 minutes. So.
Thank you, Judge.
Morning, Your Honors. All right. So first I'd like to note here that we are on a manifest weight of the evidence standard, and the appellants are asking you to reverse and find that there was no clear and convincing evidence that promissory estoppel elements were not met, and that the statute of frauds exception was not there in this case. I will give a little bit of factual background as well, where the general contractor who hired J.C. Jones Corp., the defendant in this case, where there is the promissory estoppel judgment, then hired Quanta. Quanta then hired our client, Shane Pitt, doing business as SMD Red Iron, to erect iron beams based on the fact that Quanta could not staff the project appropriately. Shane Pitt came up from Texas and staffed the project appropriately, and it wasn't until a little bit later on that J.C. Jones Corp. Found out that Shane Pitt was an additional subcontractor on the job, not notified by Quanta. So they created a relationship. J.C. Jones Corp., through the president, and Shane Pitt had a good working relationship. He staffed the job. He was doing a good job on site. So that prompted an open communication cycle where J.C. Jones hired him for a future working relationship, which sparked a conflict between Shane Pitt and the owner of Quanta, who then terminated or attempted to terminate Shane Pitt from the job. But the job had been completed with the exception of a very small portion of work. So as Shane Pitt voiced his concerns in that, hey, I want to continue to do this next project with you. However, on this project I've substantially completed. I would like to get paid for the work that I've done. So in the telephone communication, which is the center of this dispute, is where this promissory estoppel came. So what happened on the phone call was a collection of communications. It wasn't just that, please don't file a lien. It wasn't just, if you file a lien, it will mess everything up, or hey, I will try to help you get paid. It was a clear, unambiguous promise where J.C. Jones Corp. Said, listen, if you file a lien, it will screw everything up for me. If you file a lien, this will mess up my project. Do not file a lien. I will figure this out for you. I will get you paid. He relied on that promise. He took that promise, and because they had this future project together, he relied on that, and he didn't file the liens. He had those liens prepared. He could have filed them, the next day. He chose not to file those liens based on the unequivocal promise by J.C. Jones that said, I will see that you get paid for the work you've done. Throughout their conversation, they talk about, he wasn't aware that he staffed the whole project, that, you know, he was the main guy doing this portion of the work. So that's where that project came in. As far as reasonable reliance, that's easy. The reasonable reliance was, you promised me that I will, you know, you will see that I will get paid, so I'm not going to file these liens and mess it up for you based on our relationship and our future relationship. And then the damages are clear to follow in that he was not able to furnish a lien. He did not furnish a lien out of respect and based on that promise, and he did not get paid for his last portion of the contract. Was he able to sue Quanta the breach of contract? Yes. Quanta went bankrupt, and, you know, beyond, I believe, the initial, you know, answer of the complaint, they did not appear in court whatsoever. As far as the statutes of frauds arguments goes, there's a clear exception when it benefits the person who makes the promise. And that's the case that was cited heavily in here. And that's where, that's the Wilson Flores case. If the primary purpose of you making that promise to cover someone else's debts is for your own benefit, there's an exception to the statute of frauds. And that's exactly what happened here is, I need to do this so this project doesn't get messed up, so that the general contractor and the owner don't come down on me and don't pay me. I need to make this promise to see that he gets paid so that he will not file liens. The leading object of that promise and conversation was to make sure there were no liens filed so that his contract does not have issues. So I'll rest with that, Your Honor.
Counsel, I have one quick question.
Sure.
The trial court made in the verdict, both defendants jointly and severally liable. The court finds these judgments are against the defendants joint and several. What does that mean to you?
Well,
What does that mean? What's the import of that finding?
the import of that finding is that, well, J.C. Jones is, obviously they're both liable. They found they're both liable based on, you know, their separate actions. But the obvious issue there was they weren't going to be able to communicate or collect on this bankrupt entity.
Thank you.
The judgment against Quanta was a default judgment? What was it?
Yes, based on non-response. Thank you.
Thank you, Counsel.
I have to disagree with my colleague on a couple of factual statements. There is no evidence in the record of Quanta's bankruptcy. That's simply not there. If at the time that he went to the effort with his attorney to prepare an affidavit for mechanics lien, they then learned that of the notice of furnishing requirement, they'd only get 21 days from August 20th at most, at best. That's if they would run over to the recorder's office on the same day that he signed it in Cuyahoga County. That still wouldn't get him a lien because he hadn't done any work within the time period. The judgment reads as it reads, and it is, and while it seems as if the judge wanted to make an award of something, he failed to see that the evidence presented met all of the requirements of promissory estoppel in a manner that would make it be an exception to the statute of frauds requirement. There was there was work they did, and he paid for all of the work with, to Quanta that Pitt is claiming for. And then he had to pay even more in order to correct the work. And all of this corrective work took more time, and the delay caused more costs to be incurred. Now, the schedule that was presented for him to complete his work, for Pitt to complete his work, was in part a schedule, a reflection of the schedule of the total project, because there was more work to do after the PEMV part of the project was finished. And Jones was responsible to the general contractor to adhere to the schedule. So when he's behind schedule, he is concerned. And when he tells his subcontractor, you better step up, and the subcontractor tells Pitt, you better step up, and he doesn't, well, it's right that he was discharged, and the work was performed ultimately to the satisfaction of the owner.
Do you want to speak to the question of the standard of review, manifest weight versus what you might think?
Well, manifest weight is the general standard, but for reviewing errors made by a trial court on the facts. But the wrinkle in this case is that the claim is in promissory estoppel, and the judge did not make findings of clear and convincing evidence of the elements. And on the reliance element, I've shown to you where the evidence is not clear and convincing. And I think for that narrow issue, it's a de novo review, because you have to say, this is clear and convincing evidence, what was presented in the record or not.
Thank you.
Thank you.
You have about a minute. Are you ready to wrap up? Because you have a minute rebuttal time left if you wish.
I think I've educated
Well-
this panel more than it may require.
Thank you very much, Counsel. And thank both of you for your presentation today. The court will take the matter under advisement and issue a decision in due course. That decision will be mailed to you by the clerk of court when it's released, and also will be on the high Supreme